I'm very excited to introduce our last speaker for this afternoon, Dean Vikram Amar. Dean Amar is from the University of Illinois College of Law and is the Iwan Foundation Professor of Law there. He's a national authority on constitutional law, federal courts, and civil procedure, and has written a number of books and scores of articles in leading journals. He is also a frequent commentator on local and national radio and TV, and has penned dozens of op-ed pieces for major newspapers and magazines. A strong proponent of public and professional engagement, Dean Amar is an elected member of the American Law Institute and has served as a consultant for the National Association of Attorneys General, the United States Department of Justice, the California Attorney General's Office, the ACLU of Southern California, and the Center for Civic Education. He has written extensively on the subject of the Vice Presidency, and I want to welcome this afternoon Dean Vikram Amar.
Well, I know it's been a great day, but it's also been a long day with a lot of content thrown at you. So I'll try to make this last session as painless as possible. There's a lot that I'm going to say that may build on or play off of other people. I'll try not to be too redundant. I actually diverge from some of the things some other people have said, so I'll try to note those areas as well. But first, let me start with the area in which I'm completely redundant, and that is in the gratitude that I have towards the Law Review, Dean Taha, and the entire Pepperdine community, especially Doug Kmiec, my dear friend. When he called me and asked me to come to this, I really honestly wasn't sure that it was going to fit easily into my schedule, but Doug is the kind of guy that you just go send. You guys are very lucky to have him here. All right. So we started the day with the kind of very famous quote about the Vice President being nothing at all, but being everything, or the possibility of being everything. I'm not sure that the role as presider over the Senate is really nothing. I agree with Shannon that there are important aspects of that legislative responsibility. But I want to kind of identify some of the other functions that the Vice Presidency has either at the founding or has grown into, some of which kind of overlap with some of the themes others have identified. But in particular, I want to talk about the Vice President's role as a running mate, as a co-pilot, if you will, which includes not just helping the President administer, but also succeeding the President when the President suddenly leaves office. And then finally, succeeding the President after he or she is completed one or two terms. And I'm going to try to locate these roles less in a political framework and more in the constitutional framework with which I am most familiar. So first, let me talk about the running mate function. Well, the big point I want to make is this is largely a function not of the 12th Amendment, not of the 25th Amendment, not of anything in federal law. This is really a function of state law decision to ask voters to vote for a president and a vice president together. This is a very unusual thing we do when we tell voters you have to tie your vote between two people. It's more unusual today because of the specter of divided government that we have already heard mentioned a number of times. You can vote for a president of one party and a senator of the other party, a president of one party, a House member of the other party, a senator of one party, a House member of the other party, state officials of one party, federal officials of the other party, but you can't vote for a member of the vice president and a president of different parties. And the reason for that is because state law so requires. 12th Amendment doesn't say anything about this. Now the 12th Amendment, to be sure, as Ed, who slipped away, Ed Larson, he's going to come back, he pointed out this morning, and there others have echoed, the 12th Amendment certainly makes it easier for a party to elect both a vice president and president of the same ilk. But there is nothing in the 12th Amendment that requires that to be so. Indeed, it's very telling, I think, when you listen to Ed's story, that the momentum for the 12th Amendment came after the election of 1800, when Aaron Burr almost became president over Tom Jefferson, the inversion specter, not in 1796, when you had Adams and Jefferson president and vice president of different parties. There was a few proposals to change things after 1796, but they didn't go anywhere because a lot of people actually didn't mind having a president and president of different parties. It was really the possibility of the wrong person becoming president in 1800 that drove momentum for the enactment of what became the 12th Amendment. And many people opposed the 12th Amendment on the ground that it would relegate the vice president to this kind of second-class citizen, and they lamented the absence of an intra-branch check. Now, there are a lot of times when states make election law decisions because of what economists call prisoner's dilemmas. So let me just give you two that relate to federal elections. One is the winner-take-all approach to electoral college representation. Why is it that every state, save Maine and Nebraska, gives all of its electors in so-called electoral college to the candidate who wins the most votes in that state, rather than allocating the electors proportionally? And the answer is, if California has, 55 electors? If a candidate came to California and were told, hey, if you win over the median voter in California, if you win a little bit more than the other person, you'll get 28 of the 55 electors, and the other guy will only get 27. That's a far less attractive deal for the candidate than if you tell the candidate, hey, you come and you win more than the other guy, you get them all. You get the full bounty. So every state has an incentive to maximize its clout in the presidential campaign by offering the bounty of all of its electors to the candidate who comes and makes promises to win over the median state voter. And of course, once you make the promise, there's some obligation to keep it in some measure. So that's why states do that, because they have an individual. We all might agree it would be better to allocate electors on a proportional basis, but each state has an incentive to maximize its own clout unless other states are doing this, the same thing at the same time. Another example, there used to be a bit, before the Supreme Court in the Thornton versus term limits case made clear that states could not impose congressional term limits on their own, that would have to come on high through a constitutional amendment. There was some momentum for term limits, but a lot of states didn't even try to do it. Why? Because if you limit the seniority of your own members of Congress and other states aren't doing the same thing, you're really hurting yourself when it comes to appropriations. You're unilaterally disarming. And so you can understand why a state would not want to impose term limits, even if the people of that state like term limits, and even if the people of the country like term limits. There's some things you don't do because it's in your self-interest not to do them. But ticket time with regard to the vice presidency is not one of them. There's no law and econ explanation for why it is that we bind president and vice president. Now, mind you, most voters may want to vote for a president and vice president of the same party. Maybe the natural thing to do. You may like 4 years of continuity. You may want to avoid an incentive for the president to be assassinated, to get a vice president of the other party. Although notice that the common practice that's been described by Jody and the Attorney General of ticket balancing, the idea that a candidate picks a vice presidential nominee of a different wing of the party, or of a different, to try to capture a different kind of voter, that creates some incentive. And in fact, when Garfield was shot, the assassin said it was because he wanted the vice president who came from a different wing of the party to ascend. So in the end of the day, I actually think that if you unbound voters to be able to vote for a president and a vice president of different parties, you wouldn't end up with a president and a vice president of different parties. What you'd end up with is even better qualified vice presidential candidates, because you wouldn't have a Sarah Palin, because McCain couldn't take a chance for that. Okay? You probably wouldn't have had Dan Quayle. So you'd have more uniformly agreed upon high-quality vice presidential candidates. You'd have less ticket balancing, and therefore you'd have more unified White Houses. You'd actually have two people who are closer on the same page because you no longer be able to run the risk of putting someone on the ticket that was from a different part of the party because that person might not win on his or her own. And you would also have the vice president have independent electoral credibility. This goes back to something Doug talked about. To the extent that we want the vice president to have a co-pilot role, and I'll talk about that more in a moment, and you analogize, Doug, to lieutenant governors. Well, in most of the states I'm familiar with, California included, Attorney General, the lieutenant governor is independently elected, which is why it makes a little more sense for him to be able to exercise authority. Vice presidents today, and this is their biggest drawback, is they have no claim to being there other than they were tapped by the president. To those people who want the vice president to exercise a little bit of independence, independence is hard when you owe your very job, you owe your presence to another person. You didn't really do anything to earn it on your own. You were pulled up by somebody else. Now, I want to mention one other thing with regard to this ticket tying and the like. The 25th Amendment is actually much more relevant, I think, than the 12th Amendment when it comes to the president and the vice president being of the same party. And it's actually not the part of the 12th Amendment we've talked about thus far. It's not, the part where the president, the vice president ascends to be not just acting president, but full-fledged president and gets the salary and all the powers, etc. And it's not even the part where the vice president helps determine the vice president helps determine presidential disability. And although I think that is relevant because in that role, the vice president is acting as kind of the head of the cabinet. It's really a very core, executive team function. You are on this team. You're in fact you're the assistant captain of the team. And when the captain goes down, you've got to step in and head the team. But importantly, what the 25th Amendment says is when a vice president goes down, the vice president's gone, how do we fill that? We fill that by the president's choice, subject to congressional ratification, of course. But it's the president who gets to decide who replaces a vacant vice president. That is kind of a very modern explanation for why I think we do tend to think that the president and the vice president ought to go together, because the 25th Amendment reinforces that theme. All right. As I said, if the vice president were independently elected, and I don't think it's such a strange thing to ask whether we should experiment with that, there would be more credibility if and when the vice president were asked to do significant things as a co-pilot. We've heard a lot about the kinds of assistance that modern vice presidents have afforded. And by the way, I don't think it's a coincidence that these modern vice presidents get more and more power to do this after the 25th Amendment. A lot of people mark 1960 as kind of like a change point. Attorney General, you mentioned Nixon. I actually don't think that Ike gave Nixon that much to do. In fact, when Nixon ran for the president in 1960, and Ike was asked, "Can you identify?" I'm just paraphrasing. Can you identify anything that Nixon, any ideas that Nixon had that came into policy fruition? Ike said something like, "Give me a week and I'll think of one." So it wasn't as if he really did his vice president any favors in that election. But we have heard about a lot of important roles in foreign policy, in appointments, in legislation, where the vice presidents have helped the president. But I want to identify a couple of other things that co-pilots do, besides just assist when asked. Of course, the vice president is a co-pilot in the succession sense if the president dies or resigns. That's made clear under the 25th Amendment. The incapacity can be temporary, so the vice president can go back to being a vice president after the inability has resolved itself. Let me just say a few more words about the 25th Amendment because it's come up so many times here today. And here's an area where I want to diverge with something that was said earlier. Al Haig was actually right when he said, I'm in control here in the White House. He was technically wrong because, as Attorney General Meese pointed out, there was actually no presidential inability. Maybe the president was never incapacitated, that anybody needed to step in. But I and my brother have written an article, and I think a lot of the most thoughtful constitutional analysts and members, some members of government agree that it's unconstitutional to have members of Congress in the statutory line of succession. That the 1947 statute that lists the Speaker of the House and the President pro tem after the Vice Presidency in line of succession is unconstitutional. And I say this for a number of reasons. First of all, let me point out that the 47 Act was not always that way. Between the Civil War and 47, we had taken the legislators out of the line of succession for reasons that I'll mention here in a moment. But let's start with what the Constitution says. The Constitution says that Congress may specify which officers shall ascend to the presidency if the president and the vice president are both unable. Officers. Officers is a term of art used to describe executive and judicial officers. Shannon already pointed out that a vice president has to be impeached because he's an officer. Members of the House and Senate are not officers. They're not subject to impeachment. They're subject to expulsion by their respective houses. But office is a term of art in the Constitution that refers to executive and judicial, but not legislative persons. We've also heard earlier that, going back to Doug's comments, that the framers explicitly chose to reject a parliamentarian model wherein the chief executive owes his job to the majority party in the legislature. We didn't want that. We wanted independence. We wanted the president to be able to stand up to the legislature. Well, if that's so, then the last thing in the world you would want is the leader of the legislature to be able to be vaulted into the White House if the Congress impeached the president and the vice president. Creates tremendously bad incentives. And if you think this is fanciful, after Lincoln was killed, Andrew Johnson became president. Pre-25th Amendment, no mode for replacing the vice presidency, so the vice president was vacant. Andrew Johnson's impeached, comes within a vote of being convicted in the Senate, and the president pro tem of the Senate, Benjamin Wade from Ohio, who at that time was first in succession because the statute back then went President pro tem of the Senate, Speaker of the House, not the other way around as the current one did. He had already, lo and behold, big surprise, he was a big fan of convicting Andrew Johnson. And he had already reportedly picked out his cabinet. Okay? Those kinds of conflict of interest problems and the constitutional issues that they raise explain why, after that, the statute was revised to get members of Congress out of the line of succession. And in 1947, for reasons that aren't clear, it was changed back to a variant of the old approach that I think is unconstitutional. Here's another problem. The incompatibility clause of Article 1, Section 6, says no member of the House or the Senate can hold office under the United States. You can be a member of the executive branch and the judiciary ones, which is why, by the way, it's okay for John Jay to be negotiating treaties, because he's an officer of the United States. You can hold executive and judicial office at once. You can't hold legislative and executive office at once, or legislative and judicial office at once. Because the incompatibility clause says you can't be an officer of the United States and be in Congress. So let's say that the inability of the president and the vice president is temporary. If the Speaker of the House is in the line of succession, he has to resign his role, his post in Congress in order to become acting president. Can't be a member of the House and acting president at once. He's got to resign that. Well, what happens when the inability is resolved and the president comes back? He's out of a job. There's nothing he can do. Yet another illustration of how the Constitution did not contemplate that legislators could be in the line of succession. So I think we really need to fix that. I think we need to fix that especially because of today's divided government world where you often have a Speaker of the House of a different party than the president, and it's not just that we live in a world of divided government. We live in an era of divided and polarized government. Divided government wasn't as big a deal when it first came on the scene in the mid-1900s, because the difference between moderate Republicans and moderate Democrats was not that great. there was a lot more people in the center. But now, you know, the difference between any Democrat and any Republican is huge. And to have, for example, Paul Ryan, if Obama and Biden, something happened to them, for Paul Ryan to take over and finish out the term to which Obama and Biden were elected raises all kinds of legal and political problems, and we should avoid those now by fixing the statute so that John Kerry doesn't have to sue to show that, you know, he should be the one in succession, because the Secretary of State would be the next one in line after you remove the 2 members of Congress, which is why Al Haig, as Secretary of State, just like, you know, the Attorney General said, Congress kind of maybe, excuse me, the framers might not have known what they were doing, but they did something good when they created the Vice President. Al Haig may not have known, but he was making a very sophisticated and very correct constitutional argument when he implicitly said that the legislators couldn't be in the line of succession. While I'm on the 25th Amendment, let me just make one other big point. And it's kind of illustrative of how we sometimes don't even fix problems when we turn to fixing them. The Vice President under the 25th Amendment is a very important trigger person for overseeing the process of determining presidential disability. But we don't have anything to deal with vice presidential disability. What if the vice president's in coma and the president goes down? 25th Amendment doesn't say it, doesn't help us at all. I could spin out 6 or 7 different scenarios where the absence of somebody to trigger the process in the absence of the vice president being there is a problem. What if the vice presidency is vacant? Vice president dies, and before the president has a chance to replace him, the president suffers a disability. What do we do? Happily, I think a lot of these things could be fixed by statute. We don't need a constitutional amendment, but we don't have the statute in place to do it because for all these election glitches, the probability is of needing the statute is so low that Congress doesn't spend time worrying about that. But when they're needed, they're so needed that Congress ought to work now so that we're not scrambling at the wrong time. Okay. Let me talk about one other co-pilot aspect, and then I'll move on to talk a little bit about the ability to succeed somebody after they've been president rather than to finish out some or all of their term. This goes back to the series of questions that Doug was probing the Attorney General, and I was too a little bit. It's true that the 25th Amendment presupposes some kind of inability on the part of the president before full-blown presidential powers are bestowed on the vice president in the meanwhile. I guess the point I want to make is that inability needn't be physical or mental. Let me give you an example. I think it would have been a good thing if, while he was being tried in the Senate, Bill Clinton would have invoked the 25th Amendment and turned the reins over to Al Gore. Would have been good for the country because we would have, you know, Gore wouldn't have been, when the decisions he was making and the things he was doing wouldn't be hamstrung by this big specter hanging over him the way it was hanging over Clinton. I think it would have been a good thing for Clinton because it would have showed that he had the confidence to know he was going to get exonerated. In the meanwhile, he's happy to let Gore take over so that the country is not conflicted about this. If Clinton had gotten convicted in the Senate, the transition to Gore assuming power would have been that much more smooth if he was already in the office doing the job. And it would have helped Gore in 2000 because he would have had even more on-the-job training. And there's an example where, again, you know, maybe the Attorney General thinks that would be a little bit too adventuresome, but I think it falls completely within the letter and the spirit of the 25th Amendment. And if Clinton had been a little bit bigger of a mind in this regard, I think it would have been a good thing to do. Now that kind of segues me to the last set of remarks I want to offer concerning a distinctive role of kind of successor down the road. We know that a lot of individuals have become president very suddenly. So you think of Andrew Johnson, Teddy Roosevelt, Harry Truman, LBJ, Jerry Ford, all those people came very suddenly. But a lot of other people, as we know, and as Jody pointed out, have succeeded to the presidency by using the vice presidency as a stepping stone in the good old-fashioned electoral sense. Think about this. The great presidents, for the most part, extended their terms by tapping a successor who was able to take over after they finished their second term. We didn't have two-term limits until we had the 22nd Amendment, but Washington happily set a good precedent where presidents don't serve more than 2 terms, even though many popular presidents could have. But think about the presidents who kind of brought major change into D.C. and served 2 terms and what happens afterward. Okay, Thomas Jefferson, that was a sea change in 1800. Jefferson serves 2 terms. Who succeeds? James Madison, his hand-picked, not his beat, but his hand-picked successor, Secretary of State. Who else? Abraham Lincoln, sea change, 2 terms. Who wins the next election? Ulysses S. Grant, his hand-picked successor. Very close relationship between Lincoln and Grant. Truman wasn't given that much responsibility, but even he succeeded FDR. And then think of Ronald Reagan, great president. He extended his term, in essence, with George Bush winning in 1988. So being a vice president and working alongside the president can be a great platform to not only becoming president on your own, but to essentially allowing your predecessor to extend his influence. A lot of people think, well, presidents outlive their terms by appointing people to the Supreme Court. Right? The people are going to be on the court decades after they're gone from the White House. True. But a vice president can, or a hand-picked successor of some kind, can extend the influence even in the White House itself. As I said earlier, not all presidents have tried to do that. Ike didn't do that much for Nixon in '60. I think Reagan did a lot more for George Bush in 1988. The Al Gore episode in 2000 illustrates that it can be both helpful to be the vice president, but it's also complicated because we've talked about, and Jody mentioned it, you are supposed to be a loyal fellow. And how do you separate yourself from a president who's got some issues and demonstrate that you're your own man, and at the same time do right by the person who picked you and who explains your presence there in the first place? And I think you can see that Gore really struggled with that in 2000. It was a very difficult thing for him to navigate. All right. Let me make one other point about that, and then one final unrelated set of remarks, but it's consistent with the broader themes we're developing today. And then I can open it up for questions for a few minutes if we'd like, and then I'll turn it back over to Doug for closing comments. This idea that president can pick a successor, as I said, is probably, if you look at the elections since 1960, think of how many presidential elections since 1960 have featured a vice president in the general election. So in 1960, you had Nixon, he was a vice president. 1964, you had LBJ, he was vice president. In 1968, you had Humphrey against Nixon, 2 vice presidents. 1972, you had Nixon, a vice president. 1976, you had Ford, a vice president. 1980, you did not have one. 84, you had Walter Mondale, a vice president. 1988, you had George Bush, a vice president. 1992, you had George Bush, a vice president. And then 2000, you had Al Gore, a vice president. Now, 2 notable exceptions to the rule are Cheney never ran for president, we heard today. And Joe Biden's not running for president, as we know. And one interesting commonality between the two of them is the presidents under whom they served have another hand-picked successor in mind. With regard to Cheney, he was picked in part because he was a good friend, not just of George Bush, but of the Bush family. And of course, we all know that there was Jeb waiting in the wings, and Cheney was picked in part because Cheney was never going to make it hard for Jeb Bush to be president. Other things made it hard for Jeb Bush to be president, but it wasn't going to be Dick Cheney. Joe Biden, same thing with Hillary Clinton. Hillary Clinton was in some ways Obama's hand-picked successor in the way that Madison was Jefferson's hand-picked successor, Secretary of State. So even in the instances where the vice president has not run, you can see the president is still looking to extend his or her influence beyond the term through another hand-picked or designated successor. And this ability of presidents to do this was actually, I think, observed by some people at the time we considered the 22nd Amendment to limit presidents to 2 terms. One of the arguments that came up was it's undemocratic to prevent the people from continuing to elect whom they want. And if you're going to have term limits for the president, how on earth do you not have term limits for members of the House or the Senate? And one answer was, members of the House and Senate cannot grease the skids for somebody to succeed them who will carry on their work. Once they're gone, they don't have a personal ability to tap somebody else. And so, as I say, I think some of these things are implicit in a lot of things that we adopt in the Constitution, but if you look at the bigger patterns, they're quite interesting. Final point I want to make has to do with creative things that the vice presidency could do to make government work better, more generally. One of the problems with our presidential election procedures is that we have a long gap between the November election and the January inauguration. Much longer than most other advanced societies. It's a long time. And you can imagine situations where you need the new person to come on board and start acting quickly because things need to be done and a lame duck can't do them. I mean, think about 2008. Remember what the economy was happening in 2008. Obama gets elected, and George Bush was very good about trying to find out what Obama wanted to do and making sure that he wasn't doing anything that made that any harder. But better still would have been if Obama could have taken over earlier. Well, we got a Constitution. It mentions November, and it mentions January, or it gives Congress the power to set the date. We want to, generally speaking, have some time in between the two for a suitable transition. But sometimes exigencies suggest we should do it more quickly. How do you do that? Well, if Vice President Cheney had resigned right after Obama's election, and George Bush had named under the 25th Amendment Obama to be his vice president, Congress would have ratified it like that. Bush could have resigned himself, and Obama could have been a president in a week. Now, is that what we had in mind when we did the 25th Amendment? No. But there's nothing that violates the spirit or the text of the 25th Amendment in doing that. And because changing the Constitution is so darn hard, we need to make use of the flexibility that we have within the system. So I'm not saying that's something that should be done all the time, but that's something that could be done when needed. And it's triggered again by the vice president creating a vacancy that then the 25th Amendment allows the president to fill. By the way, you could do the same thing, I think, with regard to members of Congress. If a member of Congress tendered his resignation the day before the November election, that election could serve as the process for picking the person who takes over in early January when the new Congress comes in, and also the person who fills out the residue of that congressional term between November and January. So if it were important to get new people in Congress for some big thing that needed to be done right away, again, creative resignation is a way to do that. So I still have 6 minutes. I stayed under my allotment. So I'll take a question or two if people have it. Otherwise, I'll turn it back over to Doug. Yeah,
Dean Amar, if you'll just repeat the question into the microphone before
sure,
you answer.
sure. If anyone has one. Now it's been a long day, and I know we want to hear from Doug, so I don't need to say any more. But I want to make sure people have a shot. Yeah, Barry.
So, Vic, in your first argument, were you suggesting that states should allow the vice president to be elected independently of the president?
I'm not.
And what would the benefits of that be?
Okay, I'm not sure. Ultimately, I think it's something we should really think about. And the benefits would be threefold. The benefits would be you'd get a consistently better class of vice presidents. You'd get less splitting of the ticket across a party. You'd get more, the policy and ideological space between the president and the vice president would probably narrow. Because if it were too broad, you'd risk losing your base since they have to independently vote on both. Right? So if both parties split the pick a balanced vice president, so the two vice presidents are very close to each other, and one of them is more likable than the other, then a party can't count on necessarily having its vice president win, which would create an incentive to actually have more unity within the White House. So I think you'd have better vice presidents. You wouldn't have a Sarah Palin gambit. You'd have more, and the vice president would have more credibility when he needs to do something, either because the president has given it to him, or when, God forbid, he has to assume the office as a result of some tragedy. So those would be the three upsides. And I think it's worth considering, again, I haven't come to rest on it, but the fact that there's no legal constraint, no one had really given a lot of thought to this, because part of it is in an era where people weren't splitting their tickets, generally, where we weren't living in divided government, I think it really didn't occur to people. People voted party lines, in the first half of the 20th century, but now that some people actually like having, a president in one party and a Congress in one party, the question becomes, well, should we give the voters that option if the personality is so compelling in a given instance? Why do we take that out of the voters' hands?
Well, wouldn't that hurt then the co-piloting role that you then
Possible. It's possible. As I say, it hurts the co-piloting role in the day-to-day, and it helps the co-piloting role in when you need to ascend, because you have credibility then. You were selected by the people. Right? I think the 25th Amendment stands for the proposition that when we don't have another better way to pick a vice president, giving the president the power to do that makes sense, because he's the one who got elected. But when the people elect the vice president directly, that's the best still in terms of electoral legitimacy. Having a mandate through the president is better than having no mandate. And by the way, remember, people say, well, a Secretary of State never got elected, unlike the Speaker of the House. So the Speaker of the House should be in the line of succession ahead of the Secretary of State. Well, the House member got elected by a few thousand people from one district. Okay? The Secretary of State got picked by the person who got 50 or 60 million votes. Right? So I think, I'm not trying to diminish the importance of apostolic succession and the tie that you have to the president who got elected and picked you, but it's better still when the people pick you directly.
Have you looked at the dynamics between Jefferson and Adams, how that worked?
Obviously, it would depend on the moment, and again, voters can always take that into account. The question is, why is this the one way in which we take it away from voters? Right? We don't do it. I might think I prefer a Democratic president and a Democratic Congress, but my second choice would be a Republican president and a Republican Congress, because I think we need to act in one direction or the other. I think sitting in the middle is worse than acting in either direction. Let's say I believe that. We don't, right now, my voice is frustrated because, we don't bind people that way, because we let the voters decide. Why do we bind them in this one way and only this one way? Yeah.
You mentioned the 25th Amendment as a proposition
I'm sorry, I forgot to repeat the question.
That the president picks the vice president and some unity between them. But there's also the anomaly in the 25th Amendment that both houses of Congress have to consent to the vice president, whereas the president for all other officers, executive officers, judicial nominations, essentially just the Senate that weighs in it. So I wonder about that anomaly.
Well, again, I think that owes to the fact that unlike the others in the line of succession, the vice president is a heartbeat away. and we've never had someone other than the vice president ascend to the presidency. So it makes perfect sense to want to have some check on who occupies that distinctive role. And we do have a check even under our current system of tying president and vice president together, because the American people still can take into account who your vice president is in deciding whether to vote for you for president. We give the benefit of the doubt to the president, and in most instances I think people will vote for the president and not be too concerned about the vice president, but we want to make sure there's some limiting principle. And in the case of vacancy, that limiting principle is Congress. So that they perform the same function that the electorate do under the current system. So,
Additional legitimacy.
okay, I've now used up my time, so let me turn it over to our wonderful host. I assume is going to offer the closing remarks. Is that right, Doug? Or is it going to be somebody else? Rob.
I want to again thank Dean Amar for that excellent discussion to close us out. This morning we started by stating that we were going to attempt to answer some very important questions about this office and their role in our system of government. I hope that we've done at least some of that, or at the very least exposed some of the misconceptions that I know a lot of us had coming in. And again, I want to thank our speakers for doing that. Of all the lessons I've learned in my 3 years here at Pepperdine Law, perhaps the most important is if you're the last person speaking before happy hour, keep your comments very brief. However, we would be remiss if we did not thank a few people who worked tirelessly to make this event possible. First, we want to thank our administration, Dean Danelle Taha and Vice Dean Shelley Saxer, for their support of the law review and their encouragement for this event. In addition, there are many, many staff in the offices who have made this event possible. Stephanie Buckley is our Associate Vice Chancellor of Advancement. She and her staff person, Donnie Bollinger, were able to secure sponsorship for this event that made it possible, and we want to thank them. Our Communications and Tech Department, Mr. Jared Paget, who's the Associate Director of Communications, Tom Inkle, our Director of Communications, Mr. Scott Wokel is our AV Systems Specialist, and today has been working very hard to make sure that we were able to live stream this event. So we want to be sure to thank Scott. Robert McKelvey is our Campus Security Officer, and I want to thank him and his team for serving, especially with Vice President Cheney on campus today. I want to thank the Pepperdine Law Review, of course, all of our board members and excellent staffers. I want to thank our editor-in-chief, Andrew Kasabian, and our managing editor, Lacey Estudio. I want to thank, I don't think she's in the room, but please be sure to thank our events team, Suzanne Inman and McKaylee Taylor. They have done so much to make this event what it is today, and we are very, very grateful. The Pepperdine Law Review faculty advisors, those are Ed Larson, of course. The person who perhaps we owe the most thanks to today is Ambassador Doug Kmiec, who not only has helped us to put on this event, helped us to recruit speakers, but really gave us the vision for this topic in this discussion. So I want to give a special thanks to Ambassador Doug Kmiec. And then finally, unless Ambassador Kmiec, if you would like to, okay. Finally, very clear no. Finally, I want to thank again all of our excellent speakers. Thank you so much for your contribution to the symposium and just your invaluable contributions to the study of American politics and constitutional law. We are very, very grateful and honored to have you here at Pepperdine. So once again, a big thank you to all of our speakers. And with that, I'll finally thank you, our guests, for attending today, and please drive home safe. Thank you.